All right, let's talk about the Civil Rights Act of 1964 and specifically Title VII, which is what we address in much of this class. Title VII is the part of the Civil Rights Act that deals with employment, and that's why we're talking about it here. So first, what is prohibited? Well, discrimination in hiring, firing, training, promoting, disciplining, or other workplace decisions based on race, color, gender, national origin, or religion. It's a lot to say, but essentially what we've done is we've established some protected classes. These are race, color, gender, national origin, and religion. So you can't discriminate based on those factors. Later on, we'll add a couple more protected classes, like disability and pregnancy, but these are the original ones. Who has to comply with Title VII of the Civil Rights Act? Just about everybody, unless you're a small business, is kind of the nutshell answer. But the way it goes is that private employers who have 15 or more employees have to comply with the federal regulation. There might be additional state regulations. If unions have to comply, joint labor and management committees, employment agencies, all government employers have to comply. The major one that's going to wrap up most people is private employers with 15 or more employees. Who is covered under Title VII? Public and private employees at all levels, even management, everybody's covered. Sometimes we see high-profile cases where even CEOs and other high-level managers are filing lawsuits. If I'm a U.S. citizen working for a U.S. company abroad, I'm covered. If I'm a U.S. worker working for a foreign company in the U.S., I'm covered. Even if I'm a foreign worker working for a foreign company, if I'm in the U.S., I'm covered. People that wouldn't be covered would be people working for foreign companies abroad. They wouldn't get that U.S. protection. Even undocumented workers have some level of protection against this type of discrimination, though they might be limited in the amount that they can actually get in a lawsuit if they were to bring one and win one later. Who is not covered under Title VII? Well, the big exception is private employers who have less than 15 employees. So very small businesses would not have to follow the federal law. There might be state protection depending on where you live. If I can prove, and this is hard to prove, if I can prove that I'm not engaged in interstate commerce, then I would be exempt from Title VII, although I still might be covered under state law. It's very hard for a business to prove that they're not engaged in interstate commerce. You're probably getting supplies or customers or something from another state. And if I'm doing business across state lines, that qualifies as interstate commerce, which wraps me up into the federal law because of the Commerce Clause of the United States Constitution. If I'm a non-citizen employed outside of the U.S., not covered. There is an exception for businesses who are operating near or in Native American reservations. They're not exempt from everything, but they can prefer Native Americans over other workers, where in other places outside of reservations, that type of discrimination would not be allowed. There is a large exception for religious institutions. So churches, religious-owned schools, especially if I'm working in a position with religious duties, like being a pastor or teacher or some kind of minister, I'm allowed to discriminate in favor of my religion. And there are also exceptions beyond that where, for instance, some churches have beliefs saying that only men can serve some positions that women are not allowed to serve in. And that would be okay for the religious institution, where it would not be okay for a private business to say that only a man can do one thing and a woman couldn't do it. But that's because we're trying to keep the government from getting too entangled in the business of what churches do on a day-to-day basis. We got out of a system where religion and government were highly entangled in England, and the framers of the Constitution were trying to keep that from happening again. There's also an exception for bona fide private membership clubs. As long I have it, it says maybe, it depends there. It depends on whether or not I can convince somebody that I'm actually a bona fide private membership club. The most common example of one of these would be like a country club, where we can establish rules over who can be members. It's not a good idea to discriminate just because it brings a lot of bad press, but this is just sort of the time when this legislation was passed. A lot of people were afraid of some other people invading their private clubs. They didn't want that to happen, or didn't want to be forced to accept people. So we carved out this exception here. Another sign of the times in the 60s when this legislation was passed is that there was a very specific exclusion for communists. I'm not aware of this exclusion being tested in the courts anytime recently, just because communism is not that much of a threat in the United States anymore, or at least as much as they thought it was back in the 60s. So, how to file a claim under Title VII? There's a maybe rather strict statute of limitations. I had to file within 180 days of this discriminatory event happening. That might be extended to 300 days if we're also covered under state law. And that would be filing with the EEOC. The EEOC is that federal agency that that sets rules and here's cases for employment discrimination. So how does the state law plug in here? Well, a lot of states have their own similar laws to the Civil Rights Act of 1964. And they might even have their own enforcement agencies. Sometimes they're called 706 agencies. In North Carolina, we've had a lot of activity in this area recently, and things got pretty messy, and I think it's finally shaken out, but as you'll see in a minute, we have a deadline coming up where things could get messy again, so we'll see what happens. The basic idea is that we had the North Carolina Human Relations Commission, which is where private employees could go to file a claim. However, you might remember back in 2016, I think, when HB 2 was passed, had to do with a bathroom ordinance that the city of Charlotte passed, and the state reacted by further defining employment discrimination as being based on biological sex rather than just sex, because they didn't want people to interpret that to include transgenders and homosexual people. At least I think that was the intent. But it also included some other things. One of those things was that it took away the state remedy for filing an employment discrimination claim for wrongful discharge. Highly controversial that they would take away the state court route, forcing people to go the federal route through the EEOC, but that's what happened. As of March 2016, the HB rules were in effect, and there was no state remedy for employment discrimination within the state. You had to go through the EEOC. Now, this HB 2 was largely unpopular nationally. The government faced a lot of businesses that were pulling out of the state, highly influenced by athletics, the NBA, NCAA, pulling games out of North Carolina. So they started backtracking. In July 2016, they restored the state court path to lawsuits, but they did reduce the statute of limitations from 3 years to 1 year. And in a wake of more and more criticism, finally in July 2017, they repealed or partially repealed House Bill 2. Wasn't a full repeal because local governments are still barred from enacting any type of ordinance to regulate private employment practice, and they set a deadline for December 1 of 2020, which this video has been made in let's see, we're in September of 2019, so that's coming up, I don't know, next year, not too long. And we'll see what happens after that. So a little bit messy here in North Carolina, but I guess we've sort of smoothed things over for now, and we'll see how we proceed in the coming years. The remedy now, if you want to file a state claim, you'd still go to the Human Relations Commission, but now they're relocated under the North Carolina Office of Administrative Hearings in the Civil Rights Division. Okay, so let's look at what it would be like to file a claim with the EEOC. So I could approach my local EEOC office, which for us would be in Charlotte. If you are outside of North Carolina and taking this class, then you just have to look up where your local office is. So basically, I file a claim. The EEOC sends notice to the employer within 10 days of me filing that complaint. EEOC is going to encourage mediation. It's voluntary for both parties. But if we accept, then we'd enter mediation and try to find some type of solution. The EEOC is going to investigate the claim using multiple tools, including interviewing the employer, just gathering information as best they can. And we see in 2015 the average investigation time was 10 months. So you can't expect that it would be a super quick process. It might be, but you can plan on just waiting for a while. After doing the investigation, and if we aren't able to mediate a solution, then the EEOC will determine whether they think there's reasonable cause to charge the employer. If they think there's reasonable cause, then the EEOC can bring a lawsuit on my behalf. Which is great for me if I've been wronged, because it doesn't cost me a lot of money. If they don't find reasonable cause, then what they'll give me is a notice of my right to sue, otherwise known as a right to sue letter. I can then take that letter and pursue the claim in court myself, federal court. I can pursue state court outside of this process entirely. The reasonable cause finding, let's see. Like I said earlier, if the EEOC finds there is reasonable cause, then they can bring a lawsuit on my behalf in federal district court. And let's say I don't agree with the EEOC's finding of reasonable cause or not. I can try for judicial review to have a court look and see if the EEOC fulfilled their requirements. It's possible the scope of the review is going to be narrow. This coming from a lawsuit called Mock Mining versus EEOC, where the mining company accused the EEOC of not trying hard enough to conciliate, and they won, but the court did say they're going to interpret that pretty narrowly. A huge thing in the employment environment now, it's hard to understate how important this is, but mandatory arbitration agreements are becoming more and more common. If I am applying for a job and they make me sign an arbitration agreement saying that any dispute is going to be handled through arbitration, I might be giving away my right to pursue through the EEOC or federal or state courts by signing that agreement. And those agreements are, for the most part, legal as long as they're reasonable with regard to how much it would cost and things like that. But I just have to be aware of this. In order for me to sign an arbitration agreement, the employer is supposed to offer me some type of consideration in exchange for me giving up this right. But it's also been determined that an offer of employment is valid consideration for these type of agreements. So more and more people are finding themselves locked into a mandatory arbitration agreement. There's pros and cons to arbitration, so I'm not going to argue whether or not it's a good or bad thing. It's something for us to be aware of for sure. So let's say I file a lawsuit, and let's say I actually win. So how much can I get? Well, at the federal level, there are some pretty tight restrictions on compensatory and punitive damages. For the largest employers, the most I would be able to win would be $300,000, which is certainly a good amount of money. I do have to keep in mind that if I have to pay an attorney, that might not be very much money at the end of things. Um, there's no cap at the North Carolina state level, so that might be attractive to people who want to file at the state level instead of federal level. Under the Equal Pay Act, which we haven't discussed in depth yet, but we'll get to, compensatory and punitive damages are not allowed. What would be allowed is back pay for the amount that I should have been paid if I was being paid equally, and maybe liquidated damages on top of that, essentially doubling the amount that I would have been paid. In 1991, we amended the Civil Rights Act to add people's right to request a jury trial at the request of either party if we're seeking compensatory or punitive damages. So you may think that's an attractive option if you think a jury would be more sympathetic to your claim than maybe a judge would be. So I guess you have the choice there. Finally, if you were, let's say you're not successful with a Title VII claim, or you just don't think it would work out for you, there are some Civil Rights Act that came about as part of Reconstruction. So Civil War Reconstruction, as we're trying to put the country back together after the horrible Civil War. Section 1981 says that everyone has the same rights to make and enforce contracts, whereas before that, certain races may have been barred from the right to even make a contract or enforce it. The statute of limitations is a little bit longer, quite a bit longer actually, 4 years, and the amount of damages would be unlimited. So if I think my claim would qualify for Section 1981, then that might be an option. If the person who wronged me or deprived me of my constitutional rights was working on behalf of the government, then Section 1983 might be an option. It can't be used against private employers, but government officials, if I work for the government, sometimes we see 1983 claims happen when somebody's claiming that an excessive force action on behalf of the police or something like that. But there's sort of outside chances, but possible. So that's Title VII in a nutshell, a very small nutshell there. We'll continue a lot of these discussions in much more depth as we continue on with the class. But this is just a general overview of Title VII, the landscape of things, to sort of get us started.